Hello class, this is the video for chapter 39 part 2, and in this part 2 we are going to go over how a corporation is formed. We'll be talking about the promoter and the role the promoter plays. We'll take a look at the initial documents and also talk a bit about the formation process. The promoter, as I've made reference to, is the person that starts the corporation. You can think of promotion as this pre-formation stage, a pre-incorporation phase where setup is going on. The promoter is the entrepreneur or the person who will become the owner or one of the owners. It doesn't have to be. Because a professional can be a promoter as well. As an attorney, if I worked with a group of entrepreneurs and they wanted to start a corporation, I can be somewhat the promoter to assist them. I'm kind of overlapping a little bit here with the idea of an incorporator, the person that actually files the articles, all right? So as an attorney, I may take on some of the role or some of the, I would take on assistance to the promoter. All right, so what are the preliminary steps that this promoter would be involved in? Well, I have a list up here on the screen for you. It would include, their work would include preparation of the prospectus. Now that's a new term. I haven't used that with you before. The prospectus is a document that is prepared for potential investors. And so investors, before they're going to make a sizable contribution and buy some stock in this to be formed company, they're going to want to know some information. What are they getting involved in? What kind of business is this? How will it be structured? All right, that's what the prospectus is trying to deal with, to answer those types of questions and to make disclosures to potential investors in the hopes that they will be open to investing in the new corporation. All right, so the promoter prepares this or hires the attorneys and accountants to prepare the prospectus. The promoter will be out there looking for people to sell stock to, and stock the promises to buy stock, we might refer to that as a stock subscription. Right, number 3, the promoter contracts with vendors on behalf of the yet to be formed company or corporation. So the promoter may discuss a lease with a landlord, may have to retain professionals like an attorney or an accountant, and so make commitment to retain such professionals. The promoter may have to purchase some supplies in advance of starting the company up, the operation of the company up. So there's a number of things that have to be done in advance, and the promoter may be involved in the incorporation, the process of incorporation. All right, I want to take you out now to the Secretary of State's website so that you can see what the articles of incorporation look like. Before I go there, let me just go over these points on this slide. So it is signed by the incorporator, who can be anybody, like I said earlier. All right, and the articles will include some basic information about the corporation. For instance, the name of the corporation, which must be unique. It cannot be something so similar to another company where we confuse the public. All right. The articles must also identify the agent for service of process and identify the number of shares that the corporation will be allowed to issue. And so typically we'll just say put a very large number of shares, 10 million, 100 million shares into your articles of incorporation. It will have no consequence if you do not use all of those shares. All right, let me close this PowerPoint. At least get out of it and see if I can't get the articles up for you. All right, here's your textbook. Here's a form for the articles of incorporation that you can find on the Secretary of State's website. We've already looked at the LP one, We looked at the LLC articles of organization. It looks very similar. All right. I'm going to scroll down a bit just so you can see how similar it does look. Right. All right. So starting there with number 1. Am I in the right? Yeah, here we go. Number 1, you'll see it says corporate name. Number 2, business address. Number 3, service or process. Again, a corporation must have identified a person to receive any legal documents to be served on the corporation. Here is number 4, where I mentioned earlier the number of shares to indicate that the corporation will be allowed to issue. Number 5, a very generic purpose statement for all corporations in California. I'll read it aloud to you. The purpose of the corporation is to engage in any lawful act or activity for which a corporation may be organized under the General Corporation Law of California, other than the banking business, the trust company business, or the practice of a profession permitted to be incorporated by the California Corporations Code. Right? Very generic, any lawful act or activity, and then it is signed by the incorporator. Right, I'm going to return now to our PowerPoint. Here it is. Advance the slide. And return to current slide. All right, now I've described to you the promoter. You've heard a bit about the promoter's work. Let's talk now. What type of liability will a promoter have? All right, so number 1, unless it's otherwise agreed, the promoter will be personally liable for the contracts made prior to incorporation. So this is the one area. Be careful about when you are acting as the promoter. You will be liable on any obligations made prior to incorporation. Right? So you want to make sure then that once the corporation is formed, the corporation does assume, all right, liability, and that the third party vendor agrees to release the promoter. So let's say you made, as a promoter, you signed a lease with a landlord for some space for the business. Because the corporation was not yet formed, you signed it personally. The wisest thing to do would be to tell the landlord, all right, I am starting a corporation. It's not quite yet been fully formed, and I don't mind signing off right now to make a commitment to rent the space. But when the corporation is formed, ask the landlord right then, when you're signing as an individual, whether the landlord will agree to release the individual promoter and substitute the name of the corporation for the promoter. Right? That very action of letting the corporation take over for the promoter on the lease with the landlord, we call that a novation. You learned about a novation in Business 12A. I hope this is reminding you of that concept you learned in the past semester. All right, so a novation, that is your goal. As a promoter, you want all your contracts to be now turned into novations so that everything is transferred, all the obligations are transferred to the new corporation. All right, I am going to now take you out to your textbook again and put a problem from the text up on the screen. All right, this is, let me find it. I already have it up on the screen. I don't need to take you out to your textbook. I don't know what I was thinking there, but we'll take a look then. This is a problem that involves a promoter. All right, so we have 3 people, Cummings, Okawa, and Taft. They are college grads. They want to form a corporation to manufacture and sell digital tablets. Peterson tells them he will set in motion the formation of their corporation. So first, Peterson makes a contract with Owens for the purchase of a piece of land for $20,000. Owens does not know of the prospective corporate formation at the time the contract is signed. Second, Peterson makes a contract with Babcock to build a small plant on the property being purchased. Babcock's contract is conditional on the corporation's formation. Peterson secures all necessary subscription agreements and capitalization, and then he files the articles of incorporation. All right, so we want to discuss a few things here. Whether the newly formed corporation, Peterson or both, are liable on the contracts with Owens and Babcock. And then the second point we want to discuss is whether the corporation is automatically liable to Babcock on formation. All right, let's take number one. All right, who is Peterson? Based on what's been described in the problem, you can tell Peterson is the promoter. All right, so he's gone out, he's made contracts with Owens for the purchase of the land. He did not mention the corporation was to be formed. So in that case, Peterson is going to be liable on that contract. All right, he'll have to explain afterwards and see if he can get Owens to agree to a transfer of the obligation. But the way it stands, Owens doesn't anticipate that. It may be more difficult. All right, but the corporation is not liable on that. So Peterson is liable. All right, now regarding Babcock, the contract with Babcock. This is conditioned. This contract with Babcock, at least it was conditioned on the corporation's formation. So Babcock knows that he can anticipate that a corporation is going to be formed in the future, and that most likely the liability will be transferred. All right. So in that case, Peterson is not going to be personally liable because it is conditioned on the contract is conditioned on the formation. And the corporation would not be fully liable either until what? What takes place? A novation has to occur because the original contract is with Peterson. So now when the corporation is formed, we need a novation so that Babcock and the corporation are in a contract together. Right? And then number two, that's sort of addressed already in my discussion. All right. Is the corporation going to be automatically liable to Babcock? Without a novation, there's no automatic liability. So it's important that that new contract, the novation, be established that includes a release of Peterson. This problem is a decent illustration of what we're talking about here in connection with promoters. When we are establishing a corporation, there can be some issues that come up that may cause what we would call a defect. And that defect in the corporation's formation or even in the corporation's operations may then affect the status of the corporation. So this is why we have some new terms to deal with these defects that come up. All right, so we have three possible scenarios. I've made a little reference to those. Here are the three terms that go along with those three scenarios. We have the de jure corporation, we have a de facto corporation, and we have a corporation by estoppel, which does not necessarily have a defect, but it has, if you recall when I said estoppel, it'll have some fraud. So we kind of group the three terms together just so we can talk about them because there'll be some problem with the actual corporate status. So let's take each one of these one by one. De jure corporation. When we use this term, de jure corporation, it is referring to a defect that has occurred in the formation of the corporation. Right? It's probably a small technical type of defect in the articles. Generally speaking, though, the corporation has substantially complied with the requirements of the law. And so as a result, since most things have been complied with, the law will continue to recognize and treat a de jure corporation as a legal corporation. And that's important Because the consequence of being treated as a corporation, what does it do? It protects the shareholders. They are not going to be personally liable if the corporation is recognized under law. Right? Same thing goes for the de facto corporation. It's important that a corporation be recognized as a de facto corporation, even if they have messed up a bit in their operations, in the way they have maintained the corporate status. There could be a problem with their annual filing that's required under law. They may have made a mistake in it. Should that mistake be allowed to interfere with the protection offered to the shareholders? And so even though there is this fairly substantial defect, and substance may mean large, it also can refer to just substantial, meaning as part of the document itself, so it has some substance to it. All right. The law, though, will recognize and treat a de facto corporation as a legal corporation. So this is a corporation that's been operating maybe a year or two or more, and when they came time to do their annual report one year, they made a mistake. All right, that could be a substantial defect. I put another example up here. If a corporation fails to fully adopt their bylaws, which they should do initially when they first form, but a lot of times things just get forgotten and they don't get done, should that then prevent a company that's been operating from being recognized as a legal corporation? And the law has decided no, that in these two types of cases, de jure or de facto corporation situations, the law will still recognize the corporation and give them corporate status. All right, let's take a look at this third term. This third term is corporation by estoppel. All right, so with a corporation by estoppel, the business entity is not a corporation. All right, there is no corporation perhaps, but it holds itself out as a corporation. So here's that fraud I was mentioning to you. All right, someone is pretending, all right, to be a corporation, or they're just, I mean, it could have a very kind of bad motive behind it. They really are trying to cheat someone, or it could just be a bit being forgetful and kind of messy. They jumped the gun a bit and they call themselves a corporation before they actually form themselves into a corporation. So in any case, though, what's happened is that there is no corporation. However, someone has held themselves out as such. As a result, though, if they get sued, they're not going to be allowed to deny the corporate status as a defense against the lawsuit, all right, against the party that relied on their representation that they are a corporation. So what it does is it allows an innocent party to continue to with their lawsuit and to sue someone that has caused a loss to them. So an illustration of this would be in your textbook. It's a case called Brown versus WP Media. I'm going to put it up here on the screen. Let's get the textbook up here. Here it is. You can see it there. Case in point 39.4. All right, let me just read the facts to you. It says WP Media and Alabama MBA agreed to form a wireless internet services company. WP Media was to create a wireless network and Alabama MBA was to contribute the capital. Hugh Brown signed the parties' contract on behalf of Alabama MBA as the chair of its board. At the time, however, Alabama MBA's Articles of Incorporation had not yet been filed. Brown filed the Articles of Incorporation the following year. Later, Brown and Alabama MBA filed a suit alleging that WP Media had breached their contract by not building the wireless network. WP Media contended that Alabama MBA had not existed as a corporation when the agreement was signed, and thus the agreement was void. There can be no agreement. That's the argument. Supreme Court of Alabama held that because WP Media had treated Alabama MBA as a corporation, WP Media was estopped prevented from denying Alabama MBA's corporate existence. So they would have to litigate on the breach of contract action that was filed by the investors here. Just good illustration for you. You can see how the courts applied the concept that we're learning to prevent an injustice from occurring. That's the point of having a concept like corporation by estoppel. All right, let me return to the PowerPoint. And this will take us to the end of part 2. All right, we'll be moving from part 2 into part 3, where we'll have a chance to look at corporate powers.